The Renters' Rights Act is the biggest shake-up in the private rented sector in over 30 years, giving tenants more rights and stronger protections. So the question is, are you ready? My name is Sanchia Miller and I'm the owner and managing director of Miller & Vincent Properties, and we professionally manage single lets, HMOs and commercial properties on behalf of landlords. In this video, I just want to highlight some of the key changes and share my thoughts which will help you protect your assets. Now, the Act will be rolled out in 3 phases, giving landlords, tenants, councils, relevant bodies time to prepare. And if you're a landlord who self-manages, it's more important than ever to understand the legislation and consider using a professional managing agent to stay compliant and protect your investments. You may be thinking, wow, there's a lot of changes, but at the end, I will show you what the opportunities are. And we'll take a look at these key changes within each phase, starting with phase 1, which will be implemented from the 1st of May 2026. The Renters' Rights Act brings to end fixed term tenancies. And at the moment, most tenancies, they start with either 6 or 12 months fixed term. However, under the new rules, every tenancy will be periodic from day 1. Tenants will be able to give 2 months notice at any time, as long as it aligns with their rent period. And what this means is that tenancies could last for as little as 3 months. For landlords, this could lead to higher tenant turnover, increased costs, making robust tenant selection more important than ever. To mitigate this change, landlords need to understand the rules, manage notices carefully, and keep clear and compliant records. But in reality, we'll see what impact these changes have, because the average tenancy in the UK lasts for around 4 years, because tenants do value stability. The Act also introduces a 12-month protected period for tenants, meaning that landlords cannot regain possession during that first year, removing some of the flexibility to sell or move back into the property. But we'll delve back into that a little bit later. Now, it's safe to say that a lot of resources will need to be invested to implement these new rules. We've all heard of Section 21 notices, the no-fault evictions. Well, under the Renters' Rights Act, Section 21 no longer exists. Now, in practice, most landlords only tend to use Section 21 when they want to sell the property, move back in themselves or a family member, or where there's ongoing tenant issues such as rent arrears. Landlords can still regain possession for these reasons, but they will now need to rely on the new grounds under Section 8 and follow a more detailed legal process. And with Section 21 going, landlords face more administration, greater legal risk, and a higher chance of court applications being rejected. And with no major court reforms in place, this is likely to mean more delays and more costs. So it's important to secure quality tenants through robust referencing and consider rent protection and legal expenses cover to help manage the increased risk. The new grounds for possession under Section 8. Currently, there's 17 grounds, and under the Renters' Rights Act, this would increase to 36. Key new grounds include selling the property, moving back in, or serious antisocial behaviour. And if a landlord wants to sell their property or move back in, they have to provide 4 months notice, and they cannot take court action within this period. However, for antisocial behaviour, that's now a mandatory ground and requires no notice, making it easier to evict tenants causing serious issues. And as always, if tenants don't leave, landlords must go through the court process to regain possession. Evidence is required for certain grounds. For example, if you're selling, you must provide proof of a property listing. And it's an offence to misuse this ground for possession. So if you're trying to claim that you're selling the property simply just to evict a tenant to re-let it, you could face fines and prosecution. And as I've mentioned before, there's a 12-month protected period in which landlords cannot seek possession or sell during that first year. But this does not affect grounds like Section 8 rent arrears. Let me explain why evicting tenants for rent arrears is about to take much longer under the Section 8 reforms. Currently, if a tenant is in 2 months rent arrears, this is a mandatory ground for eviction, and landlords must give 2 months notice before starting court action. So that's 2.5 months before a court application. Under the Renters' Rights Act, tenants must now be in 3 months rent arrears before Ground 8 applies. and the notice period increases to 4 weeks. That's 4 months before a court application. So in short, the arrears threshold has increased from 2 months to 3 months, and the notice period doubles from 2 weeks to 4 weeks. It's important to know that if the arrears are under the 3 months threshold, ground 8 is a discretionary ground and courts will decide based on the circumstances. So with evictions potentially taking 8 to 12 months, the risk to cash flow increases. Rent guarantee insurance can help by covering unpaid rent during the eviction process, and it also may cover legal and court costs as well. And some policies may manage the process end to end, including bailiffs. Some key points to consider is that rent guarantee insurance must be taken out at the start of the tenancy. It's an extra cost to landlords, but it can help protect against long delays. So, rent increases. Under the new rules, rent review clauses are no longer valid and all rent increases must go through Section 13. As before, no rent increases are allowed within the first 12 months, but landlords must now give 2 months notice instead of 1. So rents will need to be reviewed at month 10 or you may lose a year's potential rental increase. If a tenant appeals the rent increase to the first tier tribunal, landlords must provide market comparables as evidence of a reasonable rent increase. The biggest change here is that currently successful rent increases are backdated to the notice date. For example, if a landlord serves notice in January and the tribunal decides in March, the tenant pays the backdated increased rent. Now, under the Renters' Rights Act, the increase is no longer backdated and only applies from the tribunal's decision. The risk is that tenants may delay the increases by appealing even if they think the proposed rent is fair, because they will only pay the increased rent from the date of the decision. Tribunals have the power to defer increases by up to 2 months for tenants in financial difficulties. So using Section 13 means no midterm flexibility because the increases are tied to the tenancy start date. It means more admin, as accurate tracking and documentation is a must because mistakes can void increases. So let's look at rental bidding, a strategy that has been used within the rental industry for years. For example, if a property is advertised at £1,000 rent, a tenant cannot offer £1,200 to outbid the competition and secure the property. The advertised rent becomes the maximum legal rent, and landlords and agents must not ask for, encourage, or accept offers that are higher. Now, you may still accept less than the advertised rent, but not higher. The implications are that once the property is listed, you are locked into the upper limit. So this may push landlords to be more optimistic and market their property at the highest rent from the outset. With this change, strategic pricing and strategies are imperative. Advance rent payments. You can no longer ask for or accept rent in advance before a tenancy agreement is signed. Additionally, tenants can't offer to pay 3 months rent up front to secure a property. To stay compliant, it's now best practice to take a holding deposit of up to 1 week's rent, complete referencing, take the security deposit, sign the tenancy agreement, then apply the holding deposit to the rent, then request the remaining 1 month's rent before the tenant moves in. After that, only charge rent monthly. Non-compliance can lead to fines of up to £5,000, escalating to £30,000 for repeat offenders. To manage these risks, landlords should consider obtaining the maximum holding and security deposit, guarantors, and possibly rent guarantee insurance. Rental discrimination laws are not new, but the Renters' Rights Act tightens the rules around discrimination. Now, it's unlawful to discriminate against tenants because they receive benefits or have children. Now, the Act does not force landlords to accept tenants who receive benefits. However, landlords cannot refuse an applicant solely because their income comes from benefits. That's what's unlawful. Landlords can still refuse applicants based on legitimate grounds such as affordability or referencing. So the decision is still yours. It just has to be based on lawful reasons. Adverts will also need to be assessed, as they must avoid phrases like no DSS, no benefits, working professionals only. Breaching these laws could lead to fines of up to £7,000 per offence. So it's best to use neutral wording and keep clear written records of your selection criteria to demonstrate non-discriminatory practices. Renting with pets. Under the Act, tenants have a right to request a pet and landlords cannot unreasonably refuse. What's considered reasonable refusal will be assessed on a case-by-case basis. But an example may be multiple large dogs in a small one-bedroom flat. The original bill at one stage did allow landlords to insist tenants to take out pet insurance or allowed landlords to recoup costs of a landlord-arranged policy. But under the Act, this was scrapped. Landlords cannot legally require tenants to take out pet damage insurance as a condition of consent. Landlords should therefore protect themselves through other lawful means, such as security deposits, clear clauses on pet damage liability, and appropriate landlord insurance products. Once a tenant makes a request to have a pet, the landlord has 28 days to respond, and if the landlord refuses, tenants can challenge the refusal through the private rented sector ombudsman or the courts. And if a refusal is found to be unreasonable, the landlord may be required to allow the pet. Rent repayment orders. Now, there are some key changes to these orders. Currently, rent repayment orders apply only to limited scenarios such as illegal evictions, harassment, and unlicensed properties. Under the Renters' Rights Act, repayment orders will cover wider landlord breaches, including failure to comply with improvement notices and breaches of minimum housing standards. The most significant change is that the time limit to apply for a rent repayment order extends from 12 months to 24 months. What that means is that a tenant can apply 24 months after the offence has occurred. On top of that, the rent repayment cap doubles from 12 months to 24 months. This dramatically increases the financial risk for non-compliant landlords, and this is in addition to any fines imposed by the court. In relation to enforcement, local authorities will have stronger powers to apply on behalf of tenants, especially against repeat offenders. So that's phase one. Moving on to phase two, the private rented sector ombudsman. Now, this is still in the early stages and unlikely to be implemented this year. It will act as a central register for all landlords, including private landlords with or without agents and those operating through a limited company. Tenants will be able to use this service for free to raise complaints, giving them a third-party route to resolve disputes. The aim is to resolve issues quickly and efficiently, but how effective this will be remains to be seen. It's expected that there will be a small fee to register each property, and landlords will have access to more guidance and support once the information is rolled out. The Ombudsman, they have the power to order landlords to apologise for any wrongdoing, require landlords to provide information or take action to rectify any matters, and also award fines or compensation if a landlord is at fault or found guilty. So what should landlords do? Carry out regular property inspections to ensure the property is maintained to a good standard. Complete repairs promptly and issue correct paperwork to ensure they remain compliant. We offer a free tenancy health check to help landlords determine whether their tenancies meet the required standards. So please do contact me to book a free consultation. Landlords who fail to register with the private rented sector ombudsman face civil penalties of up to £7,000, escalating to £40,000 for more serious offences. Then there's the private rented sector database. Again, it's still in the early stages and unlikely to be launched this year. But when it goes live, all landlords and properties must register online with both the Ombudsman and the private rented sector database. A very important factor is that you cannot advertise a property without registration, and portals like Rightmove will block listings without proof. Again, a small registration fee will apply and further guidance will be provided before it goes live. Parts of the database will be made public, including offences, banning orders, fines, and rogue landlord records. However, private data will be protected, but tenants and third parties will be able to see critical compliance information. It's important to note that landlords who are not registered on the database cannot serve a Section 8 notice, except under grounds 7A and 14 for serious criminal, nuisance or antisocial behaviour. For example, if a landlord wants possession to sell their property under ground 1, they will not be able to proceed until registration is complete. There are financial penalties of up to £7,000 escalating to £40,000. And for serious, persistent or deliberate breaches, this can lead to criminal prosecution. Phase 3. Now this predominantly covers Awaab's law, the Decent Home Standards and energy efficiency standards. The exact timing for Phase 3 reforms are not yet fixed, but let's look at the key points. Awaab's law introduces stricter repair deadlines for hazards like damp and mould within the private rented sector. And it will work alongside the Decent Home Standards, which ensures that all privately rented properties have no serious health and safety hazards, adequate heating, and are in a reasonable state of repair. And landlords must make reasonable adjustments to prevent condensation, including extractor fans, air bricks, and trickle vents. They cannot just blame the tenant's lifestyle, even though it's said to be the cause in 9 out of 10 cases. And local authorities, they have the power to issue improvement notices with specific deadlines. And non-compliance of these rules can lead to enforcement and civil penalties. Additionally, if repairs are delayed, tenants can complain to the private rented sector Ombudsman or take landlords to court for enforcement and compensation. It's therefore important to ensure that you have robust processes in place to ensure that your property is kept to a good standard. In relation to energy efficiency, there are proposals to require private rented homes to reach an EPC of rating C or equivalent by 2030, unless the property is exempt. Now, this legislation is still under development. So let's pull this all together and summarize the key changes. For tenants, it means more power to enforce their rights through the local authority and the private rented sector Ombudsman, to challenge rent increases, rent discrimination, unfair evictions, and more rights around pets. For landlords, some of these rules become stricter with longer deadlines and higher fines. And as a professional managing agent, we're actively supporting landlords to navigate these changes to stay compliant and profitable. In relation to enforcement, councils have much greater powers for breaches of legislation, with the ability to investigate and issue civil penalties up to £7,000, escalating to £40,000 for a lot of these offences. The quality of housing should also increase with higher standards across the private rented sector through the Decent Home Standards, Awaab's law and energy efficiency targets. Landlords must be aware that with multiple bodies overseeing compliance, enforcement risk is now broader and more coordinated. Whilst these changes can feel a little bit intimidating, most landlords already provide a good service and will only need to make small updates to their practices and paperwork. But for those that need more assistance, it's best to instruct a professional managing agent. So where are the opportunities in all of this? I'll share 5. 1. Professional landlords gain an advantage, because stronger regulation raises the standards, allowing responsible landlords to stand out and to operate in a more level playing field. 2. The Act encourages landlords to carry out a portfolio review. So this is a great opportunity to improve stock quality, exit poor performers, and invest more strategically to optimize cash flow and capital. 3. Rogue landlords, they'll exit the market, meaning more opportunities to purchase properties at a competitive price. 4. Stronger regulation can support improved lender and insurance confidence, resulting in more favourable lending and insurance terms over time. 5. Clear rules on setting rents and increases means more transparency and a fairer market competitiveness. Overall, staying fully compliant means that your property is well maintained, increasing capital appreciation, and reduces voids and tenant turnover, increasing cash flow. I hope you have found this helpful and it has given you clarity on how to navigate these changes. My focus is always on clear, practical guidance, so with this, you can go away and implement it yourself, or if you're looking for a more personalized solution with me helping implement this for you, why not go ahead and book a free consultation call now? Below this, you can see the next steps to book your call. There's no sales pitch or high pressure. Your portfolio is about your wealth building and legacy planning. And that's what I'm here to help you with. So go ahead and book your free consultation call now.